Welcome back to Lawyered Up. I am your host, Jared Moore, and as I usually like to tell you guys at the start of the program, I am not a lawyer, so I'm just a regular Joe like you guys. Well, unless you guys are lawyers, but... So tonight's program, to start off with, there's something I didn't put in the information box, and it's this child neglect case. This just dropped while I was setting the stream up, so I wanted to go ahead and cover it while it's just hot off of the presses here. You guys may remember a while back on the news, there was a case where a foster mother put her child in the backyard, and it was cold outside and the child was trying to get back in, and somebody else videoed it and then put it online, and there was an outrage, and then there was an arrest, and the mother then got transferred to Creek Nation District Court because she's a tribal citizen. Well, there was a decision handed down in that case today, and it was Caitlin Fultz is the foster mother in question, and she was found not guilty of child neglect. So she was found not guilty on that charge. I just wanted to get that in there so you guys see it. And this is going to be on the local news all over the place tonight. So if you guys want more details, you can watch that coverage. But that's basically it in a nutshell. To move on here, you guys, we have been following for a long time the Stroble case. So let me pop this up. Well, we can. This is at the United States Supreme Court now. So if you guys have been following our legislative coverage, you might have seen in a previous council meeting that there was funding approved for Stroble to get a new lawyer to pursue the case at the federal level or go on up to the Supreme Court. And so what they did was they didn't wait and do a federal case. They just filed for certiorari at the Supreme Court. Let me pop this up. So what this is Supreme Court of the United States. You can see here Alicia Stroble versus Oklahoma Tax Commission. And these are the things that have happened over here, proceedings and orders. September 29th, petition for writ of certiorari filed, and there's been some other filings. If you're not familiar with the process at the United States Supreme Court, what happens is if you have a case that you want them to hear, you file for a writ of certiorari, and then they will either grant it or they will not. It's basically the first step in the process, and there's not really like a window of time that they have to grant it. Sometimes stuff can be sitting here for years. So the link to this page is in the description of this video. So if you guys want to ever go and check on it, I'm going to be checking on it when there's something. If it is granted certiorari, then then they will put on here, when the case is going to get heard and when it's scheduled for oral arguments and all that stuff, and we'll start that whole process. If you guys followed along with McGirt or Murphy as it was before that, you'll know it's a really long process. Okay, and if you guys are curious about what the Stroble case is about, just in a nutshell real quick, Oklahoma had tax code on the books that said if you're a tribal citizen and you work for your tribal government and you live on fee or restricted land in the tribal jurisdiction, you don't have to pay income taxes on your income from the tribe, right? After McGirt and with the funding of the Mvskoke Creek Nation backing her, Stroble filed for back taxes from the Oklahoma Tax Commission, saying that now that the reservation has been recognized, all of that area is Indian country, so this tax code applies to her because she's a tribal citizen, she's worked for a tribal government. That went to the Oklahoma Supreme Court, and the Oklahoma Supreme Court denied her because they said that the McGirt decision doesn't apply to civil cases, which is what the taxes would be as a civil case, right? So, and they referenced the McGirt decision itself, where there were discussions from the justices about whether this would apply to any civil cases. The McGirt case was strictly about the 1989 Major Crimes Act in criminal cases. Okay, so that's in a nutshell. And if you guys have any questions about it, we've covered it. You can go back to previous Lawyered Up, etc., to check that out. All right, where am I at? Oh, we're going to talk about Rogers. So if you guys tuned in to our candidate videos, you may have seen some discussion happening in the chat talking about how would we determine citizenship and mentioning this Rogers test. So I found this interesting. At the time, I told the chat, I was like, I don't really know that is. I hadn't heard of it. So I went back and did some research on it. And in all my research, I found this interesting article here. There's a link to this article in the description of this video. And it basically covers the history of, hold on, let me pop it up for you guys. It covers the history of this Rogers test, and it's by Sterling M. Paulson at University of Chicago. And it is the convenience and necessity in the inconsistent legal treatments of Indian status. So basically what the Rogers, let me just go to the page I want to, I'm going to read a little excerpt from this, but I do think you guys should check this out. Put it on your iPad or on your computer or on your phone sometime. And when you have some time, just read it because it's real long. It gives the whole history of everything. But it also tells how this method, what this is. Hold on. So what the Rogers test is it's a test that federal judges and federal courts use so they can make a determination if the people being charged that they're hearing the crime against in court are Indians or not, whether the plaintiff is an Indian. So it's a two-pronged test that has whether they have Indian blood and also whether they're a citizen, right? So I'm going to read a little section in here that kind of illustrates the problems with that and explains it a little bit. But I recommend, if you guys are a citizen or you're interested in this, to read all of this because it does give the history of the Rogers test pretty good. So let's take a look at it real quick. So the dated Rogers decision stands for the idea that Indian status has both a racial and political prong, and courts continue to rely on and apply Rogers for purposes of proving Indian status in a criminal prosecution by asking whether the defendant has some Indian blood and is recognized as an Indian by a tribe or the federal government. Federal jurisdiction in Indian country, combined with the two-prong Rogers test, means that certain criminal defendants deemed Indians will be subject to federal laws, prosecution, and penalties on the basis of their Indian status, whereas similarly situated non-Indians would otherwise be subject to state criminal law. In United States v. Antelope, a group of criminal defendants belonging to the Coeur d'Alene tribe brought a Fifth Amendment challenge to this scheme. The Indian defendants committed a robbery and burglary in Idaho, but were also charged with and convicted of first-degree murder under federal felony murder provisions, as the elderly homeowner died during the robbery. The defendants were subject to federal jurisdiction and federal law by way of their Indian status and the Major Crimes Act. However, Idaho state law lacked an analogous felony murder provision. Thus, in a prosecution involving a similarly situated non-Indian, the prosecution would have had to prove premeditation and deliberation to support a first-degree murder charge under Idaho state law. But by no reason other than their Indian status, the defendants in this case were subject to a federal felony murder provision that allowed them to be convicted of first-degree murder in the absence of premeditation or deliberation. The federal prosecution need only show that a death occurred during the commission of their crime. On this basis, the defendants challenged the Major Crimes Act as unconstitutional and violative of due process, reasoning that they were subject to a stricter federal statutory scheme on the basis of an impermissible racial classification, that is, their status as Indian. The Ninth Circuit was inclined to agree, holding that the difference between Idaho and federal law put the defendants at seriously racial biased disadvantage. However, the Supreme Court reversed and rejected the defendants' challenge. The court first reasoned that federal regulation of Indian affairs is not based upon impermissible racial classifications, but rather is rooted in the unique status of Indians as a separate people with their own political institutions. By this understanding, the defendants were not subjected to federal criminal jurisdiction because they are of Indian race, but because they are enrolled members of the Coeur d'Alene tribe. The court then concluded that because the federal statutory scheme was applied even-handedly and equally to all those subject to it, Indian or non-Indian, the defendant's challenge was invalid. So I just wanted to read that because that kind of explains how that works. So these guys, they accidentally, I don't know, that there was a murder that occurred, and they were trying to escape those federal felony charges, and they were trying to say, hey, we aren't Indians for this because, and you guys can't charge us, and this is not fair. Like, we're Indians. You're giving us a double standard here. And the Supreme Court was like, no, that's fine. Now the reason we're talking about this is because there was some discussion about using the Rogers test for like citizenship qualifications. And after reading this article, I don't know if it'd be so good because this article is basically about how this Rogers test is used by the federal government to decide whether they want to have jurisdiction over people who are Indians. Like, there's some cases that are referenced in here where it's like a guy was brought into court on a crime. He didn't have citizenship, and he didn't claim that he was a Native American, but his mother had citizenship in a tribe, and the federal government said, well, because your mother has citizenship, we're going to charge you as an Indian, even though you don't claim to be an Indian and you don't have a tribal card. So that's the inconsistency that the title is referring to there. So I encourage you guys to check this article out and read it. It's pretty cool. It at least explains what the Rogers test is, so you can get an idea of that. Okay, moving on. We're at the meat and potatoes, guys. As usual, we are back on the Creek Nation Supreme Court's website, and it still looks good. It's looking good. So let's go to final opinions, because that's where we're going to find the Grayson and Kennedy case. So, before we go too far, let me give a recap of where we're at. If you guys haven't been following any of our coverage, so Grayson and Kennedy, the Supreme Court heard oral arguments in the case, and then they decided in favor of Grayson and Kennedy, which is to say that they ruled that the Creek Nation Citizenship Board had to grant citizenship to Grayson and Kennedy under the auspices of the 1866 treaty. After that decision was handed down, there was a period where it was right before the election, and there wasn't any action taken, and they didn't receive their citizenship cards. And so there was a motion for contempt filed by Grayson and Kennedy's lawyers in the case to say, hey, our clients want to have their citizenship card so they can vote in the election, and you guys aren't issuing their card, so the Supreme Court needs to hold the Citizenship Board in contempt. So the day after they filed that motion, Chief Hill issued an executive order saying that, in a nutshell, and this is all in our previous coverage if you guys want to go back and check it out. In a nutshell, the tribe's going to comply with the Supreme Court's order, but we need to change a whole lot of code and everything to make that happen, and it's going to be a process. And until we get that process done, we can't issue any citizenship card to any freedmen under the 1866 treaty, and that's what the order basically was. So after that order was issued, then the Supreme Court also made their ruling on the motion for contempt, where they decided that they weren't going to hold anybody in contempt because basically not enough time had passed. So they said we aren't inclined to hold the Citizenship Board in contempt because hasn't been that much time since we issued the order, and we believe they're going to act in good faith to do what we've ordered them to do. Okay, so that is, let me pop this up really quick. That is this order denying respondent's motion for contempt and for enforcement of order. I'm going to click it real quick just to show you guys that that was filed on August 28th. Okay? So now, let's jump forward to now. Well, not now. It was the 14th of this month. Now, hold on. Let me give a disclaimer here for why we're waiting to report this. In the previous order for contempt, the order was the motion was filed, and then the next day, the Supreme Court denied the motion and said we're not going to do it. So the reason I didn't, you can see here that this says October 14th. Excuse me. The reason I didn't report on it immediately after is I wanted to give the Supreme Court a little time to see what they were going to rule on this. And they still haven't ruled on it, so we don't know if this motion is going to be granted or not. And that's kind of important for a little bit later, a point that I'm going to get to. But you can see that it's August 28th is when they denied the previous motion for contempt, and so it's been a couple of months since then. And so now Grayson and Kennedy's lawyers have filed a renewed motion for contempt in court enforcement order, right? So they're basically saying, let me take a look here at the chat here, because I see a lot of stuff popping up. Yeah, no. Freedmen. So Pata Anu, a lot of your questions are answered if you go back on our channel and watch the previous coverage. It'll get you all caught up there. I don't want to go into everything because we'll be here for hours. But so let me bring this back up and we will go through this. The essence of this motion is saying that Chief's executive order is basically like a stalling tactic. There is and you guys can read the whole thing. I don't know how the Supreme Court's going to decide on this, but we'll find out in the future. But I do encourage you to read it if you're interested in this case. The thing that I wanted to point out here, though, is an argument that is on, where is it? I think it's page 14. Hold on a second, guys. Here we go. Okay, so I'm going to read some of the motion. Now, this is a motion that's been filed by Grayson and Kennedy's lawyers. It's not my opinion, but I do think it points out an important thing that this will, whichever way the Supreme Court rules on this particular motion is going to have an effect on how a lot of stuff that I don't know if everybody realizes. But let me read the section and then I'll explain what I'm talking about. So it starts off here. The same can be said of Chief Hill. He understands his duty to uphold the Constitution and the laws of the MCN, and although he is the head of the executive branch, he has no legal authority over the Citizenship Board's administrative functions. Then they reference the Constitution. Again, the Citizenship Board is a constitutionally created board, and Chief Hill has no power over the board beyond the appointing of its members. Chief Hill has overstepped, encroaching on the Citizenship Board's independence, violating his duty to uphold the law, and usurping this court's authority. Such willful and blatant obstruction of a lawful court order cannot be tolerated. So, and earlier in this motion, they point out that in this case and other cases, several times, Chief Hill has argued, hey, I'm the principal chief. I don't have anything to do with granting people citizenship. You know, he's said in other filings and oral arguments, I can't go into the Citizenship Board and tell them to give anybody citizenship or take any citizenship away. And what they're pointing out here is that's exactly what the executive order is doing. Is it's saying, hey, hold on, don't give any freedmen citizenship. So he's kind of like saying he can do something and not do it at the same time, right? Now, when the Supreme Court rules on this, they're going to have to say either the executive order is okay or it's not okay, right? Like either, because that's what the motion is for contempt is about, is saying he can't issue this order. And when they do, it's going to set a precedent. Now, why is that a dangerous thing? Well, as is pointed out here and is true, the Citizenship Board is a constitutional body. There are other constitutional bodies. These are things of the parts of the government that are created by the Constitution, and they're separate but equal to all the other pieces like the National Council or the executive branch. The Citizenship Board is not under the executive branch. They don't take their orders from chief. They're supposed to do what the Constitution tells them to do, right? There's also like the free press, the Mvskoke media is now a constitutional body because of the amendment we all passed. There's also the College of the Mvskoke Nation that's a constitutional body. But the thing that I wanted to point out, for instance, was like the election board. If the Supreme Court says, yeah, Chief Hill can issue an executive order and he can give orders to the Citizenship Board to do one thing or not do another thing, right? That's going to establish a precedent that Chief Hill or any other chief could issue an executive order ordering the election board to do something, right? Maybe the chief, any future chief, if that ruling happens, could say, oh, I lost the election. Well, I'm ordering the election board to throw out that election and do another one, and I'm also ordering them that I win that election, right? Because that would put the election board and other constitutional bodies under the purview of the executive branch, and he could issue executive orders to make them do whatever he wants them to do, right? That's the problem with this situation here. Okay, so as I said, I just wanted to call you guys' attention to that, and I recommend you read the thing. We don't have a Supreme Court order there to find out what they're going to say about that, and when it does, we'll report on it. I want to thank you guys for tuning in tonight. We're at 22 minutes. Let me take a look at the chat really quick and see what we've got going on here. You guys are having a great conversation here. Okay, so I don't see any questions in here, and like I said, I appreciate you guys, and we're going to keep watching this to see what happens. I'm trying to think if there's anything else that I need to state while we're in this. Oh, well, I could give you guys the lineup for next week. On the 27th, we're scheduled to have a live wire. We're going to be talking about the Blood Quantum book. If you guys go to our website, mvskokemedia.com, we had a story up about a talk that was given at TU about a book that collects people's life stories and stuff about Blood Quantum. But we're going to have some guys that worked on the book come in onto Livewire. And if you guys are interested in that, or maybe you want to buy the book, tune into Livewire and ask them whatever questions you want. Next, I think it's November 1st is when it's going to happen. There is going to be the Council Oak ceremony, and it is going to be the transfer of the Council Oak property back to the Creek Nation is what's supposed to happen. So we're going to film it, and by the end of that day, I will have a video up on it for you guys to check out. But if you're in the Tulsa area, I would plan to head to Council Oak on that November 1st Saturday and check it out. And then obviously the next weekend I think is the election. Is that right? I think so. Anyway, so let me take a look here really quick. Can you explain the Mvskoke Media Constitution thing? Oh, okay. Let me go. Oops, sorry. I flicked the wrong thing. Let's start from scratch here, guys. So, this is the Supreme Court's website. You can see here they got a tab that's Constitution. Let's go to it. Constitution. This is our Constitution. I recommend if you're a citizen or really anybody that lives on the reservation, you should read this. It's kind of the rules of the game. So the Constitution establishes the rights, privileges, citizenship, elections. See these amendments or articles here? Executive branch. So this Article 5 establishes the executive branch. It gives the rules for the executive branch, right? Let's keep going. Article 6, legislative branch. This establishes the rules for the legislative. I don't know how that happened. This established the rules for the legislative branch. We keep going down. Article 7, judicial branch. This establishes the basic rules for the court. Not the code, mind you, not the laws, but how the court's supposed to be set up and all those things. Article 8 is removal of officers. This is how you impeach people. Article 9, amendment of the Constitution. This is the process for amending the Constitution, right? You guys with me? Article 10, ratification of Constitution first election. These are the rules for that. Article 11, burials and cemeteries. Article 12, initiative and referendum. So if we keep going down, you'll see Article 13, College of the Mvskoke Nation Board of Regents. This is the article that establishes the College of the Mvskoke Nation as a constitutional body, right? Article 14, Independent Free Press. This is the article that establishes the independent free press. For our purposes, we're up here. We're going to go up here to citizenship. Sorry, went too far. And see here, this establishes that there should be a citizenship board, and it tells who shall be on the citizenship board, or what the citizenship board is made up of, and what their responsibilities are, and what their powers are. So if there's a part of the government that's established by the Constitution, right, it's at the same level as like the executive branch. So the citizenship board is at the same level as the executive branch. They're constitutional bodies. They're bodies that are created by the Constitution of the Creek Nation. And so, for instance, code can be passed by the National Council and the executive branch. But to change the composition of any of these constitutional bodies, citizens like you and I have to vote on amendments and so on and so forth. Let me see, does that explain everything? I think clear it up. So does Chief not appoint media figures for the Mvskoke media? Well, let's go take a look at that. Let's go down here to, whoops, I went too far. The Independent Free Press section. So this section establishes the free press, and it says the Mvskoke Creek Nation shall have an independent press, and that shall be free from political interest or undue influence, harassment, censorship, control, or restrictions from any department of the government of the Mvskoke Creek Nation in order to provide unbiased news and reports objectively to Mvskoke Creek citizens. For the purposes of this legislation, independent press is yada yada. Editorial board. This is the part that you're asking about there, Mike TV. The independent press shall be governed by an independent editorial board. The editorial board alone shall have the power to hire a director. The director shall oversee Mvskoke media personnel, including hiring staff. So now the composition of that editorial board is determined by the code that was passed, and Chief does have the ability to pick one. There's 3 editorial board members. One of the members is picked by the National Council. One of the members is picked by Chief, and then those 2 members pick the 3rd member, and there's some requirements on them. Those things aren't in the Article 14 because the Article 14 is more to ensure that there will always be an independent free press, right? That it still exists. They may want to pass code that changes the composition of the board down the road, like increase the number of board members and so on and so forth. Let's see here. I have a family cemetery that I needed tribe's help in preserving. Do you know what department I should get in touch with? I think there's an Indian Burial Site Act or something. Okay. Mike, I'm going to show you where to go, and we are over 30 minutes, but I'm going to do it really quick, and then we're going to sign out. So what you want to do, Mike, is, well, that popped up. If you go to the Mvskoke Creek Nation's website, MvskokeNation.com, hold on, sorry, let me bring that up for you guys. At the top here, you'll see departments. Do you see that? Let me make it bigger. There's a tab here, departments, right here. And when you hover over it, it brings up this whole other thing, right? Where you want to go is, there is 2 different places that you could contact. One of them is where is that? Geospatial is the one I'm looking for. There's a lot of stuff here. Hold on, let me make it a little bit smaller. It would be Interior Affairs, Geospatial. So here under Interior Affairs, you'll see Geospatial. Now, why am I sending you to Geospatial? Part of what Geospatial does is they use GPS to map cemeteries. So if you go to them, right, and you say, I have a cemetery, you know, that could be an Indian cemetery, they can go out and they will use their technology stuff to map that and everything and add it onto the list of stuff that's protected. That's a good thing to do. Another place that you can contact would be, where is it? Historical and Cultural Preservation. They could direct you in where you need to go to get the stuff protected, right? Or even if somebody else, for instance, owns the property, they know what needs to be filed in order to get that stuff protected, and will help you do that. Okay. Whew. There you go. I hope that helped. If not, and if you contact both of them and you don't get anywhere, you can always try one of these other departments. There's so many of them. But Geospatial does map the cemeteries, and they would at least be able to direct you to who you need to talk to get some help there. All right, guys. I don't see any other questions in there, so I am going to punch out of here for tonight. And I will see you guys on Monday at the Live Wire. Tune in because the Blood Quantum book is pretty cool, and we're going to have some guys talking about it, hopefully. This is the second time I've had to reschedule because some of the guys are professors and they have schedules that they get changed. So hopefully we're going to have it on Monday. If not, I'll let you know in what we have going on. So, Mado, Hadum, Chihichat, please.